Sorry, I short.
As the court pleases, my lord, we have an extra copy of the heads. Should the court need a copy?
Yeah, let's see. I told you it's formatted, one of the copies.
Yes, it's the same copy, my lord. We haven't changed anything.
Okay, is that so?
Yes.
Okay, fine. Thank you, ma'am. Yes, sir.
My lord, from the outset, we apologize. Our heads have got words arising from typing errors, and we'll just point out those words as we go along.
Okay, fine.
The structure of our argument will be as follows. We'll start with the issues that has to be decided within the trial, and we will then foreshadow our submissions. We will then set out the law governing those issues. We'll also set out the facts or the evidence in casu that has been tendered. And we will then briefly deal with the defense case. We will then make our concluding submissions. My lord, on page 1, paragraph 1.1, we mentioned that the admissibility of a confession statement made by accused number 1 to Lieutenant Colonel M.M. Mboto on the 30th of May 2020 at Diepkloof Police Station, and a pointing out made by accused number 1 to Lieutenant Colonel Hadebe on the 5th of June 2020, both being justices of the peace or commissioned officers, and a confession statement made by accused number 2 to Lieutenant Colonel Rapadu, also a justice of the peace or commissioned officer, on the 19th of June 2020 at Moroka Police Station, and another confession statement made to Magistrate V. Gronier at the Boksburg Magistrate Court on the 24th of June 2020. Paragraph 2, we point out, my lord, that the admissibility of all these statements is being challenged on the following basis as outlined by Mr. Ramusipili on behalf of accused number 1. And in this regard, my lord, we refer to the record of the 11th of October 2023, page 16, lines 5 to 7 and 8 to 15. Mr. Ramusipili stated the following, and we quote, "My lord, let me clarify from my perspective. My instructions are that he never made any statement," referring to accused number 1. He also denied that he made admission or pointing out. Then he added that he never made a statement. Mr. Ramusipili further mentioned that, "My lord, this is the position. As I was explaining, the making of the statement needs to be clarified because he says the statement was brought to him. He was assaulted, coerced to sign that statement." We're not going to read out the reference to the record. The court then asked Mr. Ramusipili, when you say he never made a statement, it means no statement was made by your client. He can make a statement because he was coerced to have made a statement or forced, as you say. Then Mr. Ramusipili responded, that is exactly. Then the court said the following, what do you say, Mr. Ramusipili? Then he says, my lord, this is the position. He made a statement because he was beaten up, assaulted, abused to sign that statement. The court then further asked Mr. Ramusipili, but you say it was never made freely and voluntarily. Then Mr. Ramusipili responded, indeed so, my lord. Then the court had the following exchanges with Mr. Ramusipili. The court then said, for instance, you have told this court that your client was coerced into making a statement. Then Mr. Ramusipili responded, yes. By being assaulted, he responded, yes. Then the court asked any other reason. Then Mr. Ramusipili outlined the following grounds on behalf of accused number 2. Mr. Ramusipili, my lord, let me state individually accused 1, probably referring to accused number 2. He was assaulted, Mr. Ramusipili, over a period of time, court right. Then on page 2, Mr. Ramusipili says, okay, yes. The court then said, accused 1 was assaulted over a period of time. Then Mr. Ramusipili responded, yeah, he was arrested on 16 June 2020. Then the court said, okay, wait, 16 June 2020, Mr. Ramusipili, yes. And the court said, and assaulted. Mr. Ramusipili responded, no, he was assaulted from 19 June. And we emphasize, my lord, the fact that he mentioned that he was assaulted from 19 June. Court assaulted from 19 June, Mr. Ramusipili added 2020. So in other words, Mr. Ramusipili is saying that accused number 2 was assaulted from the 19th of June 2020. Then Mr. Ramusipili mentioned that until he was taken to court. Now, my lord, I had a look at their heads, and I don't want to steal their thunder, but they mentioned they've added a further ground, namely that the rights of the accused were not explained to them, to accused 1 and 2. According to our recollection, my lord, this was not put to any of the investigating team that testified. But be that as it may, my lord, the state will submit that the accused rights were explained at every turn. In fact, it's a recurring theme in this case, like a leitmotif, my lord, that the accused rights were explained to them upon arrest and upon every critical step thereafter, and by the 3 commissioned officers as well. And I saw Advocate Mshololo is contending that the commissioned officers did not explain their rights to them.
Yeah, I just want you to expand on that, because
Yes.
you are saying this was never categorized, meaning that the fact that now it is set in their heads that their constitutional rights were never explained to them. Because
Yes.
never one of the grounds elicited when the court asked Mr.
Yes.
Ramusipili what were the reasons and grounds for saying that these so-called confessions or statements and pointing out were inadmissible.
Indeed, my lord.
Okay.
And Advocate Mshololo further goes in her heads to say that it hasn't proved that the 3 commissioners were fluent in the languages that they use, or in fact, she contends that an interpreter should have been used for accused number 1 and 2 to understand what was being conveyed to them, but this is not a ground that was raised by Mr. Ramusipili. And Advocate Msholo goes further to say that the state hasn't proved that the 3 commissioned officers were in fact commissioned officers, but this is not a ground that was raised by Mr. Ramusipili. In any case, my lord, we will argue that Section 33 of the Police Act states that the President may from time to time by commission appoint officers. So this is a formal act by the President, and we submit, my lord, that the evidence of the 3 commissioned officers should be sufficient where in the state that they've been appointed as commissioned officers. In fact, in the relevant exhibits, FF, GG, and HH, they do state that they've shown their appointment certificates to accused 1 and 2. And in paragraph 1.3, my lord, we make the point that as can be distilled from the above mentioned grounds as set out by Mr. Ramusipili, both accused deny having made the statements attributed to them, but in the same vein, they allege that they were approached by the police with statements that were already prepared, and they were then assaulted and coerced to admit and sign them. And my lord, we then make the submission that where an accused denies that he ever made a statement, he will have difficulty if he alleges at the same time that he was coerced to admit it. In our submission, my lord, the 2 possibilities exclude each other. Paragraph 1.5, we mentioned that 1 consolidated trial within a trial was held to determine the admissibility of these statements and pointings out. Then, my lord, will then, as indicated, just give an overview of our submission. My lord, in essence, what the accused are alleging amounts to this: that the police decided to concoct a story which they don't read out to the accused. They put this concocted story in their confessions or pointing out in order to make those statements their own, and they then force them to sign those statements. Now, the rhetorical question, my lord, that we ask is this: how will the police have come up with a version that stands in the confession? We ask the rhetorical question: how will the police have known what to write in those confessions? How will the police have known how to tailor the version that is germane to the 2 accused? And we will submit, my lord, that in essence the accused allege that Lieutenant Colonel Mboto, Lieutenant Colonel Rapadu, and Lieutenant Colonel Hadebe, 3 very senior and seasoned police officers, are part of this grossly irregular scheme, in terms of which some unknown police officer completes the confession with all their personal details of the accused, and all the information that appears therein, that these 3 senior and seasoned commission officers agree to make a cameo appearance and be used in this nefarious scheme to force the accused to sign the completed pro formas and the confession statements that were never read to them. And my lord, here we must keep in mind that accused number 1 was arrested earlier that day on the 30th of May 2020 before making the confession to Lieutenant Colonel Mboto. Now, the rhetorical question that we ask is, when will his pro forma, Exhibit FF, have been filled out? And when would the police have had the opportunity to concoct a story that stands in that confession, Exhibit FF? Well, we will, as we point out in the heads, will make the submission that Lieutenant Colonel Mboto testified that accused number 1 made corrections when his confession statement, Exhibit FF, was read back to him at paragraph 14.1 of Exhibit FF, which has been redacted. And my lord, we ask this question, is this the conduct of someone who has been forced to make a statement? Can someone who's been forced to make a statement make corrections? And to the question whether he has been assaulted or threatened by any person in order to influence him to make a statement, his answer was, nobody assaulted or threatened or influenced me to make a statement. We submit, my lord, that if indeed he was assaulted, as it is alleged, he would not have couched his answer the way that we have just pointed out. And Lieutenant Colonel Hadebe, on the 5th of June 2020, during the completion of the pro forma, Exhibit GG, in an office at Alberton Police Station, before the pointings out by accused number 1, he causes accused number 1 to take off his clothes of the upper body before and after the pointings out. This we have seen, my lord, as per Exhibit GG in brackets 1, photos 1 to 7 and photos 26 to 21, and there were no injuries detected. Now, this theory, as outlined above, of participation in this scheme of gross irregularities goes further, that the magistrate of Mrs. Cronje's stature similarly acts in a grossly irregular manner and holds out that a pro forma Exhibit JJ and the annexure thereto, the confession statement, were completed and signed before her, when, according to the defense, this was not the case. Accused 2 alleges that he had not had a bath since his arrest on the 16th of June 2020. And, my lord, this fact is contained in the preamble to the confession. Now, the question that we ask ourselves is, did the magistrate now suck this fact out of a thumb? Ms. Cronje had noted in the preamble that the accused had a heart condition. Dr. Hlokwe also states in Exhibit VV in brackets 1, the dental examination, that accused number 2 told him about the heart condition. And we ask ourselves, my lord, is this now a strange coincidence that both mention the the heart condition. Now, Ms. Cronje noted on page 5, paragraph C and D, that the accused had a scar on the right side of the forehead and the left eyebrow, both sustained as a small child when his grandmother tried to hit a chicken and the blow landed on his forehead. Now, the accused number 2 considered in cross-examination that he does have these scars, and the question that we ask is, how will the magistrate have known about these scars if the accused did not tell her about that? Then we revert, my lord, to our heads on...
Sorry, I'm sorry to disturb you. What about the reductions? Because as I'm listening to you, have you handled them? Did you refer to the reductions on the documents?
Yes, my lord. Are we talking now about Exhibit JJ?
Yeah.
Yes.
Because according to what I heard, is that there were certain portions
Yes.
of the pro forma which were redacted. So that information, where does it come from, according to you?
Well,
Because according to what you are submitting is that the confessions were baked, meaning they were completed and prepared, and the accused were just forced, assaulted, abused, and told to sign.
yes.
Does it include even the reductions?
Preamble. Yes, this is in the preamble, and this is not the redacted version.
Oh, it's not the redacted version.
Yes. As far as I have it.
Oh, I see. So
Unless
it's in the
if my-
preamble.
Yes.
Okay.
It's in the preamble.
So the preamble did have those reductions, which amongst others, I
Yes.
assume you say, that was incriminating evidence.
Indeed, my lord.
Okay, fine.
And now, in paragraph 2.1, we deal with the requirements for the admissibility of a confession in terms of Section 217 of the Criminal Procedure Act of 1977, which reads as follows, and we know that my colleagues are very well grounded in the law. We just putting that on record. Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such a person at criminal proceedings relating to such an offense, provided, and there's now subsection A and B. Subsection A is not really relevant. We're not going to focus on that, but rather on subsection B. Subsection B contains two subsections, Roman figure 1 and Roman figure 2. Roman figure 2 contains a presumption which has been declared unconstitutional in the case of Zuma, which we shall revert to in due course. But it's subsection B, Roman figure 1, that we are going to focus on, my lord. Subsection B reads that where the confession is made to a magistrate and reduced to writing by him, or is confirmed and reduced to writing in the presence of a magistrate, the confession shall, upon the mere production, and here the emphasis, my lord, falls on upon the mere production thereof, at the proceedings in question, be admissible against such a person if the following grounds are met: if it appears from the document in which the confession is contained that the confession was made by a person whose name corresponds to that of such a person. Now, here, my lord, we submit that Exhibit JJ shows that the confession is made by Bongani Ntanzi, which corresponds with the name of accused number 2. And in the case of a confession made to a magistrate or confirmed in the presence of a magistrate through an interpreter, if a certificate by the interpreter appears on such documents to the effect that he or she interpreted truly and correctly and to the best of his ability with regard to the contents of the confession, and any question put to such a person by the magistrate. Now, my lord, on page 9 of Exhibit JJ, there is indeed a certificate by the interpreter which reads as follows: I, Evelyn Tsepiso Mutlaping, certify that in terms of Section 217 of Act 51 of 1977, as amended, I have interpreted truly and correctly and to the best of my ability with regard to both the contents of this statement and everything said by the magistrate. And we point out, my lord, that in our submission, the conditions that have been laid down in subsection B, Roman figure 1, have been met. Now, paragraph 3, we point out that the prosecution may lead evidence in rebuttal of evidence adduced by an accused in rebuttal of a presumption under subsection B. We submit, my lord, that the state has done so through the evidence of Ms. Cronje, Mrs. Mutlaping, Sergeant Mukhani, as well as Constable Lizeran.
Sorry, yeah, I hear you. Just for my edification, there was no pertinent attack on the competency and qualification of Ms. Mutlaping as an interpreter.
No, not at all.
Maybe he didn't understand the language, etc., etc.
Yes,
there is no attack per se.
No, not at all. In fact, there was little cross-examination. I think there was 1 or 2 questions that have had nothing to do with her competency as an interpreter.
But further, remember Mr. Ramosepili, when he was adducing the reasons why he says the confessions and the pointing out of number 1, for instance, were not made freely and voluntarily. The primary reason he gives was that this was a complete document. It was brought complete for accused number 1, for instance, to sign. Are you with me?
Yes, indeed. I think he was attacking it on 2 fronts. He said the accused admits that he signed the preamble, but that the annexure, that is the confession itself, was completed, and then he was forced to sign it at another place in Germiston.
Yes. Yeah, Germiston, yeah.
Yes.
And then number 2, does he pertinently say that who forged Ms. Machaping's signature? Because
yes.
as an interpreter, she alleged,
Yes.
she testified that she signed.
Yes.
You just read the certificate.
Yes.
Was there any submissions from the defense about that fact, whether in fact they just let it lie that Ms. Machaping also signed?
No, that was
Was
never.
it attacked?
That was never an issue, my lord. The only thing that was an issue initially was that accused didn't sign it, but then this was later watered down to say, you know, he did sign it to indicate that he asked for, for soap and
Yeah, fine.
and for a bath.
And
Yes, yes.
no, but yeah, pertinent.
Yes,
but
but that was not.
it was never put,
yes.
for instance, that Machaping must have signed this document somewhere.
No.
Because her
yes.
evidence is that, as you read the certificate, that she correctly interpreted to the best of her ability the evidence, the questions and what Ms. Kronje
Yes.
was saying.
Yes.
That was just left at bay.
Yes, no, indeed, my lord. No issue was taken with her regarding the signature on
Okay.
on the certificate.
Oh, fine.
Then at paragraph 3.1, my lord, is relevant. It deals with the confession elicited in cross-examination.
Okay.
Then paragraph 3.2, we make the submission that it is opposite to know that the presumption or reverse onus placed on the accused in terms of section 217 in brackets 1, Roman figure 2, that we have just referred to, was found to be inconsistent with the Constitution and declared invalid in the case of State versus Zoom and others, 1995, volume 1, SACR 568, and is the decision of the Constitutional Court. The effect is that where these admissibility requirements are in issue, the state must prove beyond reasonable doubt that the confession is admissible.
Okay.
However, we make the submission, my lord, in paragraph 3.3 that section 2171B regarding a confession made to and reduced to writing by a magistrate or confirmed and reduced to writing in the presence of a magistrate is still applicable.
Okay.
And that such a confession is admissible upon its mere production in the proceedings in question, provided that the name of the person making the statement correspond with the name of the accused, as we've mentioned, that the person to whom the written statement was made is a magistrate. We've called Ms. Kronje to testify about that. And where an interpreter was used, it must be proved that the person who issued the certificate in terms of this section was the interpreter. We interpreted the statement. Ms. Machaping testified and confirmed that, and that the certificate relates to the statement in question.
Okay, but fine. I hear you. And then what about the fact that you say the document, that is the pro forma forms, encapsulated the names of the they allegedly encapsulate the names of accused number 1 and number 2. Are you with me?
Yes.
In the form, according to what you were saying.
Yes.
It has got the name, the surname, the address, the ID number, whether it's male or female, etc., etc. That information, what was the submission by the defense? Who furnished that information, in other words? Because the submission, I recall, is that this document came, or the pro forma, it was never filled in their presence.
Yes.
Are you with me?
Yes, indeed, my lord.
Because one of the requirements was that the name of the person whose name appears in the confession corresponds with the name.
Yes.
That's one of the requirements.
Yes. My lord, I also grappled with the same question, and I had a closer look at their heads to see what they're saying, but all that they're saying they're not saying in so many words that the accused did furnish the information in the preamble. All that they're saying is that the accused does admit that he signed and initialed the preamble, but as to whether with his own mouth he said or he uttered what is stated in the preamble, that, my lord, the defense hasn't really put up a version. The only version that is before court is that of the witnesses, my lord, the magistrate, and the interpreter, that the accused did in fact state what stands in the preamble.
All right.
Then in paragraph 3.4, it is respectfully submitted that Exhibit JJ, the statement made to Magistrate Vic Cronje at the Boksburg Magistrate Court on the 24th of June 2020, in the presence of an interpreter as well as the legal practitioner of accused number 2, Mr. Mjiako, to which we shall revert in due course, complies with these requirements, and it is therefore admissible upon mere production. In cross-examination, accused did not, in fact, the accused considered that he was not assaulted prior to making the statement on the 19th of June before Mrs. Cronje. He was only assaulted afterwards, when he was allegedly taken to a dumping area near Germiston and forced to initial the statement. Ms. Cronje testified that she handed the statement to the head of office, Mrs. Dupree, after it was completed. Now, the question that comes to mind is, why would Ms. Cronje allow a document that has not been initialed? I'm talking about the statement itself, the confession itself. Allow the annexure to the preamble or the confession statement not to be initialed, but testify in court that it was initialed in her presence. The suggestion by the defense is that she permitted an irregularity by allowing a document that hasn't been signed to leave her office, then to come to court and testify that it was signed in her presence.
Okay, sorry, Mr. Member, I haven't read your heads, so I'll go along asking this question.
Sure.
You say the submission by the defense is that Ms. Cronje committed an irregularity.
Indeed.
Is that the submission? Not fraud.
Well, there's the import of the...
What is it? Is it fraud or an irregularity?
Well, it's fraud. In fact, it's
yeah, it's
fraud.
It must be fraud.
Yes.
Because...
just putting it mildly.
Okay. Oh, is that so?
Yes. But that is the effect of what the imputing to Ms. Cronje. Okay. We mentioned further that accused denied having made the statement and that he merely appended his signature on Exhibit JJ to indicate that he has complained about not bathing and that he had requested toiletries. But this is in contrast to what was initially put to Ms. Cronje, that accused number 2 denies having signed the statement that includes the preamble. And paragraph 3.5, we mentioned that Ms. Cronje testified that after she and the person with whom she had the interview with, known as Mr. Bongani Ntanzi, had indicated that he was satisfied, then she requested him to sign each and every page in her presence, in the presence of the interpreter, as well as in the presence of his legal representative, Mr. Mjiako, and we refer to the relevant part of the record. It was also initialed by the interpreter and the deponent, and my lord, what is important is that she stamped these documents. The stamp used is a stamp that was allocated to her in person and sent out to her as a magistrate. She testified that after the parties had left the office, and that includes the interpreter, the deponent, this is now accused number 2, his attorney, Mr. Mjiako, she then handed this exhibit JJ to Mrs. Du Plessis, the head of office, who then made copies and handed her a copy later that week. And in paragraph 3.6, we ponder about this fact, my lord, as to this question that immediately after the parties have left her office, she handed the document to Mrs. Du Plessis and not the police. Now, the question that we're pondering about is how will now the police, if Ms. Cronje kept Exhibit J, if she kept this statement, how will now this document have reached the police to force accused number 2 at the dumping area, as they've mentioned, to sign this annexure? And we point out that in Exhibit JJ, it has the stamp of Mrs. Cronje on it, confirming that it is the document that she completed and was signed and initialed before her by the accused. The accused alleges that the document that he signed should have blood stains on it, coming from the injuries from the assault. But my lord, as we have seen when Brigadier Gininda displayed Exhibit JJ before this court, the statement has no blood stains on it. In paragraph 3.7, we mentioned that the interpreter, Mrs. Motlaping, testified that she borrowed accused number 2 her pen to initial and sign the statement. And Ms. Cronje testified that accused number 2 appended his signature after the conclusion of the statement as appears on page 8 of Exhibit JJ.
Yeah,
And-
sorry.
Yes.
Just before I forget this. Was it ever attacked, the evidence of Mrs. Motlaping? Was it ever attacked that you never handed accused number 2 a pen to sign?
No, in fact, my lord, in
the other way around?
Yeah, in cross-examination, the accused conceded that,
Oh, he considered?
Yes.
That?
that Ms. Motlaping borrowed
Who gave
her
her
the
the pen?
pen to sign.
Oh, I see.
Yes.
Okay.
Ms. Cronje testified that accused number 2 appended his signature after the conclusion of the statement, and that portion reads as follows on page 8 of Exhibit JJ, and we quote, "The statement is now signed by the deponent by means of his signature, and the signature of accused number 2 appears below those words. There is no signature at paragraph 8 of the pro forma, where accused number 2 alleges that he signed that portion to indicate that he requested a bath to contact his family and to have a change of clothing. Only his initials appear at the bottom of that page. We therefore submit, my lord, that the version of the accused ought to be rejected as false. Then at paragraph 4, we deal with the requirements for the admission of a pointings out in terms of section 219A of Act 51 of 1977. There, my lord, we refer to the case of State versus Shihama, 1991, volume 2, SA 860 is the decision of the appellate division. And there, my lord, the appeal court, Judge Hoekstra, as he then was, he held that a pointing out is a communication by conduct, and such statement by the person pointing out that he has knowledge which prima facie operates to his disadvantage and can constitute extracurrial statement. And again, in Tebeta, 1959, volume 2, SA 337A at 46B to D, again, Judge Hoekstra was part of that bench. Don't know if the same Judge Hoekstra is some almost 30 years earlier. He held that, and we quote, when a person points out a thing, the pointing out is his act and proves that he has knowledge of some fact relating to that thing. And we also refer to other cases of State versus Kumalo, January, and we then, in Kumalo, it was also held that admission is an extracurrial statement. We refer to section 219A, which provide as follows: admissibility.
Sorry, maybe I must confess. The case of State versus January, I was involved in it.
1994, volume 2,
Yeah,
SSCR
1994.
801. Oh, that's.
Yeah.
Yes. I didn't look at the bench.
Okay.
Yeah. Subsection 1 of section 219A reads as follows: evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall, if such admission does not constitute a confession of that offense and is proved to have been voluntarily made, and that is the operative word, my lord, voluntarily made by that person, be admissible in evidence against him at criminal proceedings relating to that offense. The next two paragraphs are not really relevant. And we turn to page 7, paragraph 4.2. We make the following submission that the following requirements must be met before an extracurrial statement by an accused is admissible. Firstly, it must be made by the accused, and secondly, it must be voluntary. And we refer to the case of State versus Yolelo, 1981, volume 1, SA 1002, the decision of the then appellate division at page 1009C, where the Supreme Court of Appeal held that section 219A merely codified the common law requirement of voluntariness with regards to admissibility of admissions. And the court then quoted the that locus classicus of R versus Berlin, 1926 AD 459 at 465, where in the case of State versus Berlin, the court held that, and we quote, "The common law allows no statement made by an accused person to be given in evidence against himself unless it is shown by the prosecution to have been freely and voluntarily made, in the sense that it has not been induced by any promise or threat proceeding from a person in authority." That is a principle covering all admissions or statements made by the accused. So the state has to prove that the admission was made free of promise, inducement, or threat from a person in a position of authority, or other threats which may induce a court to find that it had not been established beyond a reasonable doubt that the admission was made voluntarily. And threats imply a causal connection between the threat and the acceptance. It may be direct physical violence or indirect pressure exerted on the accused, and it is always a question of fact, and we refer to the case of Berlin and Mahoti. We furthermore, my Lord, refer to the case of State versus Mpeta. We don't seem to have quoted it in the heads, but it's State versus Mpeta and others.
Mpeta, ne?
Yes. Volume 2, the second case of Mpeta, 1983. Volume 1, SA 576, and it's the decision of the
Cooper.
Cape Provincial Division.
Yeah, Cooper.
Yes, Williamson J, I think.
Williamson, sorry.
Yes.
I know that case because of the politics of the time.
Yes.
Mpeta was a prominent ANC member who had gone to Angola, blah, blah, blah.
Yes, indeed, my Lord.
Yeah.
The court then explained the term freely and voluntarily as set out in Section 217 of the Criminal Procedure Act, and held that the word voluntarily in Section 219A of the Act seemed to convey essentially the same idea, and for all practical purposes, there is no meaningful difference between the word as used in Section 217 and as used in Section 219A. And the court further held that in determining what amounts to undue influence, obviously threats or promises are important factors. But the court held that in general terms, any practice is undue which, if introduced into our law or into our code of law, would be repugnant to the principles upon which the criminal law is based. Then the court went on to quote the case of R versus Masinyana, 1958, volume 1, SA 616. It's also the decision of the appellate, the then appellate division, S621, where Van der Neefer JAS then was held the following: the notions freely, voluntarily, sound and sober senses, and undue influence with which the proviso operates are plainly concepts, use them generis or of the same kind. Voluntarily, sound and sober senses and undue influence relate to factors which are calculated to negative the exercise of free will. So in other words, my lord, the court is saying that, you know, all these factors denote basically one thing, and whether the will of an accused was negatively impacted upon.
Yeah, sorry, what is the full citation? Van den Heever, you said.
Yes,
The judge.
it's Masinyana, R versus
R versus Masinyane.
Masinyana, yes,
Okay.
1958, volume
1,
1, SA 616
616.
at 621, and is the decision of the appellate division.
Okay.
And the court also referred to this case of R versus Kuzwayo, 1949, volume 3, SA 761 at 768. And it's also the decision of then the appellate division. Then the court in Mpeta's case, quoting from Kuzwayo, stated that the test should be put as follows, and we quote: was or was not the confessor's will swayed by external impulses improperly brought to bear upon it, which negative his freedom of volition. He said the test must be couched as follows. Has it been established in the particular instance that the alleged confession was voluntary? It is clear that the confessor's will was not swayed by external impulses improperly brought to bear upon it, which are calculated to negative the apparent freedom of volition. So in other words, my lord, the question that needs to be asked is whether the conduct of the police in this case was calculated to negative the free will of accused 1 and 2. And we will submit, my lord, that the evidence show that the police did not in any way influence the free will of accused 1 and 2. We will remember, my lord, that at some point on the 30th of May 2020, after the accused had made the confession to Lieutenant Colonel Mboto, when he was returned by Constables Munareng and Mapumlo, that Brigadier Gilinda said to accused number 1 that you've mentioned that you want to point out the Inyanga, but go and sleep over it. But please keep in mind the rights that I've read out to you. My lord, we submit that is not the conduct of someone who wants to sway the will of an accused. Then we at paragraph 4.7, we briefly deal with the issues in this matter, as whether the state has succeeded in proving that the requirements of section 217 and 219A have been satisfied. We refer briefly to the judge's rules, and we make the submission, my lord, that the judge's rules are applicable in this matter. And as we've already mentioned, when evidence was given during the testimony of, I think it was Brigadier Gininda, or one of the state witnesses, that at a conference of judges, certain rules were drawn up to render protection to suspects. And it's interesting to see that even in the UK, these judges' rules are applicable. And that the Department of Justice has accepted and published these rules. And we refer again to the case of Mpeta. And we mentioned that Section 35 of the Constitution has now entrenched some of these rights as fundamental rights. And we mentioned, my lord, that for instance, if there's non-compliance with Rule 8A, that will be an infringement. Section 35 of the Constitution provides inter alia that an arrested person or detained person should be informed of his right to legal representation, the right to silence, and the possible consequences if she elects to make a statement. And we refer to sub-rule 2 of the judge's rule, which reads as follows: questions may be put to a person whom the police have decided to arrest or who is under suspicion, where it is possible that the person by his answers may afford information which may tend to establish his innocence, as for instance where he has been found in possession of property suspected to have been stolen. And my lord will recall, this is the constant debate that we've always had with the defense, where they insisted that that a formal form should be completed that was handed up. And we mentioned this instance that, for instance, where someone has been found in possession of property suspected to have been stolen, or of an instrument suspected to have been used in the commission of the offense, or where he was seen in the vicinity of the crime when it was committed. In such a case, caution should first be administered. Questions, the sole purpose of which is that the answers may afford evidence against that person, should not be put. For instance, my lord, in this instance, accused number 2 is asked where he was on the 26th of October 2014 when the deceased was killed during the question in the boardroom on the 17th of June 2020. He offers an exculpatory explanation that he was at work at Sibanye Stillwater. Now, the police go with him there to Sibanye Stillwater. They peruse the records and establish that he wasn't at work. And Rule 5 of the judge's rule reads as follows: where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is, my lord, what we are sitting with, that that accused number 2 is arrested for the Nongoma case, accused number 1 for the Tembisa case, and at the same time there's whilst these cases are being investigated, the main case is also being investigated. And this we've clearly seen in the recent case, my lord, in KZN, involving a high-profile musician who was shot, the case that appeared in court last week. Rule 6 is really not applicable in the current instance as caution was administered. And Rule 7 says a prisoner making a voluntary statement must not be cross-examined, but questions may be put to him solely for the purpose of removing elementary or obvious ambiguities in voluntary statements. For instance, if he has mentioned an hour without saying whether it was morning or evening, or has given a day of the week and day of the month which do not agree, or has not made it clear to what individual or what place he intended to refer in some part of his statement, he may be questioned sufficiently to clear up the point. Then Rule 8 is not really of any relevance here. We go to Rule 9, which states that any statement made in accordance with the above rule should, whenever possible, be taken down in writing and in the language in which it was made. It should be read over to the person making it, and he should be given full opportunity for making any corrections therein that he may wish to, and he should then be invited to sign it. This we've seen a lot with all the confessions. We know that in South Africa we make use of interpreters, and in all the relevant instances, in the case of Ms. Cronje, an interpreter was used, but in the case of Lieutenant Colonel Mboto, Hadebe, and Rapadu, all testify that they are proficient in the Zulu language, and hence they dispense with the services of an interpreter. I see that Advocate Mshololo is attacking that point. Paragraph 5.4, it's not really relevant. We go into skip that. Paragraph 5.5, page 10, it is respectfully submitted that the investigation that was conducted in this matter falls within the ambit of the judge's rules that we have referred to above in detaining the accused and obtaining their confession statements, and that the police took great care in ensuring that the accused are informed of their constitutional rights at every critical step, and such explanation of the rights has been documented and handed in as exhibits. For instance, Exhibit LL in brackets 1, Exhibit TT, as well as in the occurrence books, Exhibit KK, MM, NN, PP, QQ, and SS. The next, my lord, we deal with the summary of the evidence presented by the state in a trial within a trial. We're not going to quote our heads verbatim, but just with a broad brush, my lord, we refer to the evidence of the state in the following broad categories. Roman figure 1, the evidence of the cold case unit, investigating team, and the entries made in the occurrence books. Roman figure 2, the evidence of the SWAT members who provided escort details to the cold case unit. Roman figure 3, the evidence of justices of the peace and the photographers. Roman figure 4, the evidence of the magistrate and the interpreter. Roman figure 5, the evidence of the dentist, Dr. Tabang Hlokwe. Roman figure 6, the evidence of on automated vehicle location, or AVL, by Mr. Michael Jacobus Dupree. Roman figure 7, the evidence of the defense will then be dealt with. As far as the evidence of the cold case investigating team, my lord, they dealt with the mandate of the cold case unit, and Brigadier Gininda testified as follows. Yes, my lord, so the mandate of the cold case unit is to look at all unresolved matters, unlike from what we've heard from Warrant Officer Makubo, that they look at shelf matters. Testify that we look at unresolved matters, or rather criminal cases that are brought to our attention. It basically entails, my lord, cases that have gone cold. In other words, they were not successfully brought to court for prosecution. And he said that is the essence of their mandate, and this was further elaborated upon by Sergeant Mohola, who testified as follows. It is to investigate, my lord, the stagnant, complex, unsolved cases, and also, my lord, to assist other investigators at the stations or other units to come to the conclusion. And it was on this basis, my lord, that the cold case unit then took over the investigation in this matter, as it was on all fours with their mandate. And Brigadier Gininda testified as follows. Yes, indeed, my lord. So the case, it is under First Lawrence Case 636-10 of 2014. It relates to the murder of Senzo Robert Meiwa, who was killed on the 26th of October 2014. And we then asked him, when was his unit seized with the matter? He says it was seized with the matter on 18 November 2018, my lord, sorry, 12 November 2018. And this we apologize. I think earlier on in cross-examination he said 2019, it's actually 2018. He further testified that accused number 1 became a person of interest. They started profiling him and discovered that he had an outstanding case, Tembisa Case 217/3/2019. So at the time when accused became a person of interest on this matter, we did what we call a cold case analysis, and that is now the profiling of the accused, or rather the suspect at the time, through the cold case analysis and profiling this particular matter of Tembisa Case 217 was picked up, and amongst other cases in relation to accused number 1. And it was discovered that this Tembisa matter, my lord, and the others that we picked up were all cold cases for some reason. Hence, they were then drawn, my lord, for further investigations, and that is how we came to the issue of a warrant insofar as the matter is concerned. Then there was reference to the arrest of accused number 1 on the 30th of May 2020, and we are on paragraph 7, my lord, where we deal with the events on the 30th of May 2020 and the arrest of accused number 1 by female Sergeant Mohola. She testified that Brigadier Gininda allocated the case docket Tembisa Case 217/3/2019 to her in November of 2019, and she proceeded to obtain a J50 warrant of arrest against accused number 1, Mr. Muzi Sibia, in December 2019. That as a result of information, she proceeded to Tembisa. She contacted Constable Butelezi of Ekurhuleni Special Weapons and Tactics, or SWAT, as well as Constable Sadiki. They noticed 3 males were standing in a yard. She effected an arrest assisted by Constable Buthelezi and Sadiki. In fact, Constable Buthelezi testified that he did what he called the takedown arrest. She testified that his rights were explained to him, and that the accused offered to take them to his shack, as she put it. And upon arrival there, they then conducted a search and found ammunition, magazine, and a cleaning rod. Thereafter, the accused number 1 then offered to take them to Vusimusi Hostel in Tembisa to trace the firearm. And
is it not in Vosloorus?
In Tembisa, no.
Oh, is that so?
In Tembisa, no. And that the search there, or the visit to the Tembisa hostel, did not deliver any positive results, and she then asked Buthelezi and Sadiki to give a private moment with accused number 1, so that she can speak to him. Accused number 1 was seated in the car. She warned him according to his constitutional rights, and she asked him about his involvement in the matter of Mr. Senzo Robert Meyiwa. That when accused number 1 responded to the question which was posed to him, she could see that he was making admissions. She then contacted Brigadier Gininda, who advised that they should meet at Vosloorus police station before proceeding to Baswitini hostel, where accused number 1 offered to take them to. She asked accused number 1 if he was comfortable with her communicating what he was telling her to, as she put it, her boss, Brigadier Gininda. Accused number 1 responded that he did not have a problem. Brigadier Gininda suggested that they should meet at Vosloorus police station before going to Baswitini hostel in Vosloorus, as would like to question him further. They then met at Vosloorus police station at the parking area. She introduced accused number 1 to Brigadier Gininda, who was a colonel at that stage. And that Brigadier Gininda also introduced himself to accused number 1. Brigadier Gininda then warned accused number 1 of his constitutional rights and asked Sergeant Mukhola to give him a moment with accused number 1 so that he could question him further. And Brigadier Gininda then went into the vehicle wherein the accused was, which was a red Golf. And after the questioning, Brigadier Gininda said that they should perhaps put the issue of going to a Baswitini hostel in abeyance, so that he can start making arrangements for accused to make a confession. Then Brigadier Gininda then indicated that they can leave to the provincial head office in Araton as he was making those arrangements. Paragraph 7.3. Upon arrival at Araton, accused 1 went with her in the office with Brigadier Gininda. They were then joined by Constable Monareng and Constable Mapumlo, and the Brigadier then handed accused number 1 to them, and they went away with him to where he was supposed to make a confession. They went to Diepkloof police station after the Brigadier has made arrangements. She waited in the office. Paragraph 7.4. Constable Monareng and Constable Mapumlo then came back with accused number 1 after 12 midnight. The brigadier then handed over accused back to her and said that she can continue with the investigation. She indicated to accused number 1 that she will come and fetch him during the day about the information which she has told the brigadier. And as we mentioned, and told accused number 1 that he can sleep on it, and that he must keep in mind his explanation of his constitutional right. And she then took accused number 1 back into the vehicle, and they left Pretoria with Constable Sadiki, Constable Buthelezi, and Constable Monareng and Constable Mapumlo to detain accused number 1 at Vilera Police Station. And upon arrival at Vilera Police Station, entry number 2187 was made on the 31st of May 2020 at 0140 as per the occurrence book exhibit NN, and reads as follows: Transito. Arrest Sergeant Mkhola from National Commissioner's Office, cold case investigation with the following: Moses Themba Sibiya, CAS 217/3/2019, Tembisa South. And there's also an SAP 14 number. This, my lord, SAP 14 number, as the witnesses have testified, it's the pamphlet containing the explanation of the rights.
Okay.
And says J50 warrant of arrest, no injuries, correctly detained, and Sergeant Mkhola countersigned this entry. And she gave accused number 1 the notice of rights at 0140 on the 31st of May 2020, and a copy of those rights served as exhibit TT. And I've had a look at the submissions by Mr. Ramsepeli. In fact, they are not disputing that the accused had no injuries. I think they're saying that the police assaulted the accused in such a way that no injuries were left.
Is that the submission? No, he was assaulted but no injuries?
Yes.
Sorry, but he's referring to the assaults, the 3 or 4 assaults of the 30th.
Yes, indeed, my lord.
You know, it just struck me. The defense will obviously deal with that. It just struck me that when accused number 1 was arrested, when he was at his check, as you call it, he was taken to Vosloorus, and he was taken, I think, to
They first went to Tembisa,
Tembisa
to the hostel.
To the hostel.
Then to Vosloorus, my lord. And
At
from
the municipal
Vosloorus
place.
I'm sorry, my lord.
Municipal offices.
Oh, yes, yes. At Letabong, I think.
Right,
yes,
yeah.
yes.
Where, I mean, one would imagine in a municipal office, it has access to the residents of whatever location. And the police chose to go and assault the accused there. But what was striking, which I'm sure the defense will address fully, the accused one, I don't think I'm misquoting him, says that there was a red vehicle. Remember, there was a red vehicle which came and it parked.
Yes.
And that there were police in uniform, etc., etc. But the gravamen of the thing is, he says there were 13 men who assaulted her. 8 plus 5. Those 7 vehicles came there.
Yes.
And he says there were about 8 policemen in those vehicles who were called by apparently Mabena and whoever as people to come and help with the security. And that
Yes.
also in the other 2 cars, or 3 cars. There were 5 other men, and
Yes.
all of them assaulted him at 4 or 3 different occasions.
Indeed, my lord, that is the initial version
That's it.
that was put to
13 men.
to the witnesses, my lord.
Okay, fine.
As it's 3:28, will this perhaps be...
Oh, okay.
I'm just looking at that portion on their heads quickly, if
Where they,
regarding the injuries.
well, his evidence, I think accused number 1's evidence is that he did have injuries, but he qualifies that by saying that his body was abused and sore, and that we all know that the police have a manner of assaulting you in order that your injuries should not show and be visible.
Yes, indeed, that is what is stated in the heads, and I think they go further and say it was not expected that injuries would be found on
Yeah,
the
after being assaulted by 13 men
on the
in uniform with guns
on the accused.
and whatever.
So court is
Carrying
not-
guns, in other words. Not that they assaulted him with guns. Okay,
If we can then adjourn the stage, ma'am.
we are adjourning now.
Is it possible, this?
Okay, tomorrow then.
Ungakhathazeki bafethu, zonke izinto azishoyo ngizona ukunikela zona kusasa uma eqeda ngaphambi kokuthi abameli baqale nabo ngeinkulumo zabo.
Yeah, you have to interpret for them.
That's
Also,
the court business.
after, not after, let's say, just do it, have the heads, and do it up to the way Mr.
Baloyi is
where he ended now, ne? So that when you start with the interpretation. Then
That's the court.
maybe tomorrow you'll do the same. Day after tomorrow.
Yes.
Because it's a lot of information to process.
Yes.
That's why Mr. Balois has even forgotten that there was a red vehicle there. Why, Mr. Numal? Was there a red vehicle there, sir? Which came with 7, 8 men. I don't remember that evidence.
I do remember.
And then it became 8 plus 5. And then they trapped him. At 4 occasions, different occasions. Okay, tomorrow.
Ah, no.